Good. Our chief guest of the day, Honorable Justice Madan B. Lokur, Shri Prakash Singh, Chairman IPF, Dr. Vipul Mudgal, Director Common Cause, Shri Sudhir Pratap Singh, former DG NSG, and all gracious ladies and gentlemen present online to witness this event. Present online today are several senior police officers, including heads of police forces, retired police officers, distinguished civil servants, civil society leaders, jurists, lawyers, those representing NGOs, and friends of the IPF. Good afternoon to everybody, and a very warm welcome to every one of you here. My name is Ramchandran. I am president of the Indian Police Foundation. We are holding today's events online in the backdrop of the COVID-19 pandemic. And I must bring to your notice that as of today, as we speak, more than 1 lakh police personnel across India have been infected with COVID-19. And as many as 576 police and CAPF personnel have died, most of them having contracted the disease while trying to shield us from the virus. We start today's deliberations on this solemn note, remembering those police and CAPF personnel who have lost their lives to the pandemic. Today, we are observing the 5th anniversary of the IPF. It was on 21st October 2015 that the IPF was launched and inaugurated by the then Union Home Minister, Honorable Shri Rajnath Singh. I wish to mention here that the purpose of setting up the IPF was not to add to the vast and growing mass of criticism against the police or indulge in further whining and complaining against the police, because there are plenty of persons doing that job already, a good job of it they are doing. Our purpose is to work with the Indian police to look for ways and means to raise the professional, ethical, and service delivery standards of the police, to generate the big and the small ideas through research and constructive deliberations, and to find practical solutions to the policing challenges of today and tomorrow. Ladies and gentlemen, it was 14 years ago, December 22, 2006, that the Supreme Court delivered its historic judgment on police reform. The Indian Police Foundation has been observing 22nd September every year as the Police Reforms Day since its inception. Today we are honored because today we have Honorable Justice Madan B. Lokur, former judge of the Supreme Court of India and presently a judge of the Supreme Court of Fiji, who has very graciously consented to deliver the IPF Foundation Day Lecture 2020. Justice Madan B. Lokur is too well known for a formal introduction. We know him as one of the most eminent and respected judges of the Supreme Court of India. He is a judge who had an immense presence in the Indian judiciary arena. He was a judge of the Delhi High Court. He served as Chief Justice of Guwahati High Court. He also served as Chief Justice of the High Court of Andhra Pradesh. He served as a judge of the Supreme Court of India for nearly 6 years and a half, from June 2012 to December 2018. Justice Lokur is known as a judge with a deep sense of justice. We know him for his intense concern for the rule of law and citizens' rights. In him, we see a rare blend of simplicity, humility, and intellectual integrity of the highest order. Justice Lokur has shaped the human rights jurisprudence of the country, covering the rights to food, shelter, health, dignity, and livelihood. He has also nursed and monitored the social justice bench of the Supreme Court with great compassion and humanism. Sir, we eagerly look forward to listen to you. Ladies and gentlemen, before I request Justice Lokur to deliver the Foundation Day lecture, there are a couple of announcements to make. That is, after the lecture by Justice Lokur, the Shri Prakash Singh, Chairman IPF, will be speaking briefly, and that will be followed by questions and answers to be curated by Dr. Vipul Mudgal, and Justice Lokur has very graciously consented to answer your questions. Another important event is that this event will be, that is the current event will be concluded by 5:25 p.m. and the next event begins at 5:30 p.m. The next event is a conversation that Faye D'Souza will be having with Shri Prakash Singh and Maya Daruwala. So those in the audience, please note that you have to log out of this current session after its conclusion at 5:25 p.m. and again log in for the next session, which starts at 5:30 p.m. The links for the next session has also been circulated. It will be on your mails and WhatsApp messages. Now, may I now request Honorable Justice Madan B. Lokur to deliver the IPF Foundation Day Lecture 2020. Thank you.
Thank you, Mr. Ramchandran, and congratulations to the Indian Police Foundation and Common Cause for organizing this event, and of course to Mr. Ramchandran, who is the president of the IPF, as well as Mr. Prakash Singh, who is the chairman of the IPS and the motivating force behind police reforms. And ladies and gentlemen, distinguished guests who are present here today. I will be speaking about police reforms and criminal justice reforms. I believe both of them go hand in hand, and criminal justice reforms will have some meaning if there are some police reforms that back them up. So I have actually divided my presentation into 5 different categories, 5 different segments, and I will be indicating them as we go along. The first segment is a brief background to police reforms. As you all know that it was in 1977 that the National Police Commission was set up. They gave 8 reports, the last one being in 1981, on various aspects of police reforms. Unfortunately, from 1981 onwards till 1996, no steps or no concrete steps seem to have been taken to implement the reports of the National Police Commission. And this led Mr. Prakash Singh and Common Cause to file a writ petition in the Supreme Court for the implementation of the police reforms. The Supreme Court also took 10 years to come to a decision in 2006. But in the meanwhile, certain other committee reports had come up. For example, the Ribeiro Committee, which gave 2 reports in 1998 and 1999. the Padmanabhaya Committee, which gave a report in the year 2000, Malimat Committee, which gave a report on criminal justice reforms in 2003, Soli Swarajji Committee, which drafted a model police act in 2005-2006. And yesterday, I came to know from a response given in the Rajya Sabha that there was a Mushahari review committee in 2004-2005. This does not find a mention in the judgment of the Supreme Court. Frankly, I do not know why. But the Mushahari Review Committee also gave certain suggestions, as many as 49 of them, for police reforms. But anyway, Mr. Prakash Singh's case was decided on 22nd September 2006, which is 14 years ago. One of the very important observations made by the Supreme Court in its judgment, and I quote, they say that none of the state governments or union territories urged that any of the suggestions put forth by the petitioner and the Solicitor General of India may not be accepted. So everybody, state governments, union territories, Government of India, they all agreed that the recommendations of the National Police Commission should be implemented. But unfortunately, we are still, 14 years down the line, but no progress has been made in this regard. The Supreme Court recommended some systemic and structural reforms. I will just mention them, the important directions that were given by the Supreme Court. One was to set up a state security commission. Second, the selection of the Director General of Police and a minimum tenure of 2 years. Third, a minimum tenure of 2 years for the Inspector General of Police and other officers. Fourth, investigating police to be separated from law and order police. Now, this is very important in the context of criminal justice. 5, establishment of a police establishment board which would deal with administrative issues such as transfers and so on. And number 6, setting up a police complaints authority. Now, there is a report which was released on 20th of September, 2 days ago, by the Commonwealth Human Rights Initiative, and I would request all of you to go through that report, because that indicates that not a single state, not a single union territory that is under the control of the central government has implemented all these reforms. Some states have made some changes, some states have not made some changes, some states have set up the Police Act following the Soli Swarajji Committee report, others have not. So really, the compliance of the directions of the Supreme Court are wanting, even after a gap of 4 years. One of the questions I think that may need to be answered at some point of time is this contempt of the Supreme Court? And if it is, what is it that can be done to make sure that the report, that the directions given by the Supreme Court are implemented? The second segment that I would like to address you on is something which affects the common citizen. It affects all of us. And that is with regard to procedural reforms and democratic rights of citizens. When a crime is committed, a person goes to the police station to lodge an FIR. There have been problems about the non-registration of FIRs, and a recent decision given by the Delhi High Court indicates that in the 1984 riots, Sajjan Kumar, who was at that time a prominent politician, he was somehow or the other involved in 5 deaths that had taken place. But he was quite powerful. Nothing seems to have happened. And eventually, the trial court acquitted him. Ultimately, the matter came to the Delhi High Court, and the Delhi High Court convicted him. The appeal is now pending in the Supreme Court. But the problem really is that there was a refusal to register the FIR. Delhi High Court has had to deal with a few cases in the recent past. There is one case of 2007, Radha versus the state. What had happened in this case was that Radha's brother was abducted and killed. The police refused to register an FIR. The incident was of 2007. When the matter reached the Delhi High Court, the learned judge who was hearing the case remarked that the functioning of the Delhi police was sordid, despotic, and nepotic. And in a brazen and blatant and contemptuous manner, they have flouted and defied the law. The learned judge imposed a penalty of rupees 2 lakh by way of costs on the Delhi police. There was another case of Gurmeet Singh, also decided by the Delhi police. I'm giving examples of Delhi, but you will find examples like this in almost every state. The case of Gurmeet Singh was a case of gang rape, and the FIR was not registered. The ASI actually advised the complainant that why should an FIR be registered, and if at all an FIR has to be registered, let it be registered under the provisions of Section 107 and 151 of the CRPC, which of the IPC, which deal with breach of peace. Now, gang rape was thought of as by the ASI as a breach of peace. Now, there were conflicting decisions from various courts. Some of them said that it is mandatory to register an FIR. Some of them said it is not mandatory to register an FIR. The police should carry out some kind of a preliminary investigation before registering an FIR. But eventually, a constitution bench of the Supreme Court in 2013, in the case of Lalita Kumari, they held that it is mandatory to register an FIR when a complainant comes to the police station. There were a few exceptions that were laid out by the Constitution bench, such as in matrimonial cases, commercial cases, medical negligence, and so on. One of the things that was considered by the Supreme Court was the fear of misuse of the provisions of law. But that's again, a view that has been expressed by several people outside the court, particularly with reference to Section 498A of the IPC. But the 243rd report of the Law Commission of India said that there is no empirical data to suggest that the provisions of 498A of the IPC are being misused. So really, once the Constitution bench has laid down the law that it is mandatory to register the FIR, I don't think the police has any option not to register the FIR. Notwithstanding this, post the Lalita Kumari decision last week, I think it was last week only, the Supreme Court in the case of Neeta Kumar noted that this lady's son, the body of her son, who was a student of the National Law University in Jodhpur, was found near the railway tracks. It took her 10 months and a lot of persuasion to have the FIR registered. The police carried out investigations and gave a closure report. But when the matter came to the Supreme Court castigated the police and said that why should it take 10 months post Lalita Kumari to register the FIR? The Supreme Court was also unhappy with the investigations that were carried out and ordered fresh investigations. From Tripura, I have two cases, the other end of the country. Nikhil Chandra, where one lady was driven to suicide by her husband, but the FIR was not registered. Last month, in spite of the decision of the Tripura High Court in Nikhil Chandra, in the case of Deepika Chaudhary, she had participated in a demonstration. She was badly roughed up by the police. She went to lodge a complaint, but the FIR was not registered. So really, it is a democratic right of every citizen to report and register a crime, particularly when that person is a victim. And it is the obligation of the police to follow the law laid down by the Supreme Court. But we see that even after the Constitution Bench decision, the law is not necessarily being followed. We come to the next segment, which is about fair investigations. Now, after the FIR is registered, you need to have fair investigations to find out whether the person who is being accused of an offense is actually guilty or not. Now, it has been reported that in 2019, Delhi had over 3 lakh cases that were registered under the IPC. Every 4 hours in Delhi, there was a rape. I've been informed that there are in the region of 178 police stations in Delhi, but for the sake of calculation, let's take 200 police stations in Delhi. What this means is that each police station on an average has 1,500 cases at any given point of time. Of 2019, I'm not talking about the backlog. So really, with this kind of pressure that the police is working under, there are bound to be allegations of shoddy investigations. And this has happened in any number of cases. I had mentioned, of course, not from Delhi, but I had mentioned about Jodhpur, where the Supreme Court had remarked about shoddy investigations. But you have similar situations in other places also. Again, in August this year, the Supreme Court remarked in a case of Gangadhar versus the state of Madhya Pradesh. This was not strictly a police case, but it was a case under the NCRB. And they said that the investigation was casual, perfunctory, and shoddy. So really, the police and the agencies associated with the police in some way or the other, they are under a huge pressure of work. The United Nations has suggested that there should be 222 police officers per 100,000 citizens. In India, out of 222, the sanction strength actually is 185 per 100,000 citizens. But the actual strength is 144 per 100,000. So really, you can see that the police is working under a lot of pressure. They are bound to make mistakes, but at the same time, something has to be done. We can't say that, well, it's all right if investigations are shoddy. It's all right if criminals get away. It's all right if innocent people are put behind bars. There's a lot of pressure of work. What can be done? That can't be an answer. And the answer has to be police reforms. Otherwise, you will end up, with hundreds of cases where the courts will be saying that the investigation is shoddy, you've got the wrong person, and start all over again or acquit the person because of shoddy investigations. What I find really somewhat more disturbing is that there is now some kind of a trust deficit, that is coming in to the police investigations. And I would like to mention a few, cases in this regard. You have the case of Hyderabad, where a lady was raped and subsequently murdered. The police, during the course of investigations, they took the accused persons to the scene of the crime. The allegation was that these people tried to snatch the pistol from the police, and in self-defense, the police had no option but to shoot all of them. Four of them were killed. Ordinarily, one would assume that there would be some kind of a investigation to be conducted by the police, but the Supreme Court said that the investigation, well, not really the investigation, but an inquiry into this, into what transpired, will be conducted by a committee headed by a judge of the Supreme Court, a retired judge of the Supreme Court. I think that's an instance of trust deficit. More recently, in the encounter in which Vikas Dubey, believed to be a notorious gangster in Uttar Pradesh, also killed in an encounter, the Supreme Court again appointed a committee headed by a retired judge of the Supreme Court to find out what exactly transpired. You have, in the case of Bhima Koregaon, for example, when the state government decided to set up an investigating team to find out what actually transpired, suddenly the central government said, well, we are transferring the case to the National Investigating Agency. Why is that? Because there was no trust, they had no faith in the impartiality of the police in Maharashtra. In Tuticorin, sometime in June, two persons, a father and son duo, Jaydev and Benix, were thrashed by the police for keeping their shop open beyond the required time. And the matter is being looked into by the CBI, the premier investigating agency, and for 3 months, they've not been able to tell us what has happened. The inquest proceedings by the magistrate under section 176 of the CRPC, not yet concluded. We have been witness to what has been described as a circus in the Riya Chakravarti case, the suicide/murder of Sushant Singh Rajput. The matter is with the CBI. Couple of months have passed by and we still don't know whether it was a suicide or whether it was a murder. Now, these are instances where the common person feels that if the premier investigating agency, if the investigating agencies of the state cannot be trusted to do a fair investigation, how are we as common citizens, how are we going to exercise our democratic rights? Are we likely to get justice from the police? Are we likely to get justice from the courts? Because if the investigation is defective, shoddy, faulty, mala fide, where is the question of getting justice? So these are things, which we have to look into. A fair trial is the next step after a fair investigation. And a fair trial has been held by the Supreme Court to be a human right. But before we get into the question of a human right and a fair trial, we first have to try and find out how do we redeem the trust that the people have or should have in the investigating agencies. Is there merit in the direction given by the Supreme Court that there should be a distinction between the investigating wing of the police and the law and order wing? And if there is, why is it that it is not being done? Why are we unnecessarily putting pressure on the police so that we get these strange results. The fourth segment that I would like to address you on is dealing with the people, police dealing with the people. There are reports that have come. I think that is from the Center for Studies of Development for Developing Societies. 29% of the respondents trust the police. 55% of the respondents believe that there is corruption in the police. These are not good figures. Look at custodial deaths. And I'm not talking only about custodial deaths in police stations, but also custodial deaths in prisons. Between 1st of April 2017 and 28th of February 2018, that's about 11 months, there were 1,674 custodial deaths, out of which 144 of them took place in police stations. This is based on a reply given in the Rajya Sabha on 14th of March 2018. What this means is that during that period, there were 5 custodial deaths every day on an average. I think the police need to show some compassion. They need to show some empathy when dealing with people. Frankly, I do not find any reason why persons who are 80 years old, 81 years old, 82 years old being kept in jail, in custody, as under trials. The provisions for bail are so well settled by the courts, particularly by the Supreme Court. How do you expect a person who is 82, 83 to abscond? Perhaps that person is not in good health because of old age. Should that person continue to remain in jail? Let's look at it, from a compassionate point of view. Let's look at it from a point of view of empathy. You have a pregnant young lady who was in jail, and the state acted as if it was showing some great magnanimity and saying, well, she's pregnant, but as an act of magnanimity, we are not opposing her bail application. But this should not be treated as a precedent. You're not doing a favor to somebody. You have to, the state has to follow the law. It has to show some compassion to the people of the country. After all, nobody in the country is an enemy of the people. There may be some, certainly there may be some, but not, the common man or the common woman walking around on the streets. I think we have to look into that. The National NHRC, National Human Rights Commission, has also recorded a large number of custodial deaths. They've been looking into it. Unfortunately, the recommendations of the NHRC are merely recommendations. They need not be acted upon, and unfortunately, they are not being acted upon in a large number of cases. This gives a handle to the police, some sort of a feeling of impunity that, all right, even if we go a little beyond our brief, nothing much is going to happen. You have areas where the police file multiple FIRs, which is one after the other on different events which unfold but are basically related to the main event. This is being used to keep persons in custody. And we had a situation fairly recently where one of the agencies, not a police agency, but one of the associated agencies said, well, we are not going to examine the person who's an under trial or who's in judicial custody until he comes out. And when he comes out, we're going to ask for a remand. And that is exactly what happened. So really, this is something which is unfortunate, and which I believe the state should not do to a citizen of the country. A lot has been spoken about the use of the law of sedition and the Unlawful Activities Prevention Act. Bail is routinely rejected under the Unlawful Activities Prevention Act. It is routinely rejected in cases of sedition also. Now, the Delhi High Court recently gave bail to some person allegedly involved in the Delhi riots on the ground that there was absolutely no evidence. Video cameras were present. CCTV cameras were available. There was absolutely no evidence, but this person had to spend time in jail. Why are we doing that? And by keeping people in jail, by the way, the NCRB has indicated that the percentage of jail population has increased. Last year, it was in the region of, last year meaning 2018, it was in the region of about 112% or 113%. It has gone up to 118%. So, by very strictly interpreting the law, by using a heavy hand against the citizens, there is some collateral damage. One collateral damage, of course, is the increase in the prison population. The other that we are facing now, today, is the possibility of getting infected with this COVID-19 virus. The Supreme Court has said that please try and see if you can release people so that the jails do not become places of hotspots, as they are called, for COVID. Well, initially people were being released, but now things have slowed down. And there are many jails where there are a very large number of people who are COVID patients. Different, categories of prisoners, under trial prisoners, convicts, different age groups. So there is a collateral damage, to having this heavy hand sort of a syndrome that is being adopted. I would recommend very strongly that the matter should be taken up by the National Police Academy, by other academies, that there should be training not only of police officers but also of judges, sensitization that we have to be compassionate, we have to show some empathy, we have to consider that a person is innocent until proven guilty. Unless we come back to the old philosophies that we have, the jurisprudence that has been developed over the years, bail, not jail, I think we are going to continue in this fashion for a considerable period of time. I would now like to discuss a little bit about criminal justice reforms. Like I said, police reforms and criminal justice reforms go hand in hand. A criminal case comes to the court only when there's an FIR, only when there's a proper investigation, only when there's a charge sheet. And unless we reform the police in the line and in the context of what the Supreme Court has said and in the directions that the Supreme Court has laid down, we are going to have, cases where FIRs should be lodged but are not being lodged. We are going to have investigations that are shoddy and which are set aside, and then again the court says, well, you have a de novo investigation. It serves really no purpose to have a de novo investigation or to transfer it to some other agency, because the whole process has to be gone through again. And who suffers in the process? It's the public who suffers. Where the same crime or the same alleged crime is being investigated again and again, it doesn't serve any purpose at all. Coming back to criminal justice reforms, on 26th of November 1985, that is Law Day, that is when the Constitution was passed by Parliament on 26th of November. The then Chief Justice of India, Justice Bhagwati, said, and I quote him, he said, "I am pained to observe that the judicial system in the country is almost on the verge of collapse. These are strong words I am using, but it is with considerable anguish that I say so. Our adjudicatory system is creaking under the weight of arrears." This was said by the Chief Justice of India in 1985, which is 35 years ago. What is the position today? Today, in the district courts, according to the e-courts website, there are 3.46 crore cases that are pending in the district courts. 72% of these cases, that is 2.5 crore cases, are criminal cases. 58 lakh cases, or 25% of the criminal cases, are more than 10 years old. This is in the district courts. In the high courts, we have 51.5 lakh cases pending. I read in the newspapers a couple of days ago that in November 2019, 44.75 lakh cases were pending in the high courts. So in less than a year, between November 2019 and September 2020, the number of cases that have increased, the pendency of cases that has increased in the high courts is roughly about 7 lakhs. 28% of all the cases that are pending in the high courts are criminal cases. That is 14.7 lakh cases. More than 3 lakh cases, that is 20% of the cases, are pending in the high courts for more than 10 years. I don't know what the figures were when Justice Bhagwati gave his speech on 26th of November 1985, but I'm pretty confident that the numbers were nothing, absolutely nothing compared to what they are today. This is the kind of problem that we are facing today in our criminal justice system. The number of persons who are under trials, lodged in jails, is as high as 69%. These figures are available from the prison statistics that are given out by the NCRB. In the district courts, the number of vacancies are 20%, which is roughly slightly over 5,000. In the high courts across the country, the number of vacancies go as high as 40%. The budget for the judiciary is 0.54% of the national expenditure. Now, with these kind of figures, how do we expect any improvement in our criminal justice system? How do we expect any improvement in our justice delivery system? Forget about the criminal justice system. I think it's a very, very long shot. Now we have more and more cases coming up on issues which are far more serious. Sedition, for example. There were 30 cases in 2015. In 2018, 70 cases. That is more than double. I'm pretty sure in 2019 and 2020 there would have been more cases. Now these are serious cases. Sedition is a serious offense. Unlawful Activities Prevention Act. In 2014, 976 cases. In 2018, 1,182 cases. The number of cases that are pending under the Unlawful Activities Prevention Act, again, a very, very draconian legislation, is more than 5,000. So not only is the number of cases increasing dramatically, but the gravity of the offenses are also coming up. Earlier, we did not count cases pertaining to children, sexual offenses against children. Today we are. So all sections of society, whether they are children, whether they are women, whether they are male adults, whether they are young girls, all of them today are becoming a part of our criminal justice system in some form or the other. How are we going to tackle this? I don't know. It's very difficult to understand how this problem can be tackled. And then you have NGOs who are being told that, well, you are conducting some kind of unlawful activity. For example, Fridays for Future is an NGO dealing with environmental issues. They objected to the environment impact assessment notification, draft notification given by the government of India. They were told that, well, action is going to be taken against you, perhaps under the UAPA. Other similar NGOs such as Let India Breathe, There Is No Earth B, these two have been told that, well, if you object too much to the EIA notification, action is likely to be taken against you. So the range of issues is also broadening. And in my opinion, broadening a little unreasonably. Where a person is protesting against a notification that is being given by the government. After all, if you're inviting suggestions, if you're inviting objections and somebody objects and you say, well, you're objecting, so I'm likely to take action against you. What is the point of inviting objections? I think these are really, issues that I think we must consider very, very seriously. I would say that if you look at the trajectory of cases, the trajectory of issues, the range of issues, the quantity of cases, I'm not sure whether what Justice Bhagwati said in 1985 is valid today, that the criminal justice system or the justice delivery system is on the verge of collapse. It might have already collapsed. It is difficult to see how 3.5 crore cases can be dealt with. It is difficult to see how 2.5 crore criminal cases in the trial courts can be dealt with effectively. Are we on the verge of collapse or have we already collapsed? I think we need to look at this. There has to be, in addition to police reforms, in my opinion, a concerted effort to bring about reforms in our justice delivery system, particularly in our criminal justice delivery system. We can't afford to wait like we have for police justice, for police reforms for 14 years. If we wait for another 14 years, I think if we wait for 14 months, we are inviting very, very serious trouble. And I will not be surprised maybe next year when we meet again on 22nd of September. It might be too late to say that, criminal justice system is surviving in the country. We need to think about it. All of us need to think about it and see how we can get back to a position that was pre-1985, before Justice Bhagwati voiced his apprehensions. We need to go back 35 years. I leave you with these thoughts, and I thank you for giving me this opportunity to share some of my views. Thank you very much.
Thank you, Justice Lokur, for what was a very stimulating talk. And you have touched several important and very sensitive issues which are agitating all thinking persons. Talking on the subject of police, you drew our attention to the problem in the registration of cases. It's a huge problem. We all agree, sir. I would just like to bring to your notice one simple thing, that quite often we are under enormous pressure not to register cases. I come from UP. I'm telling you specific instances. In one case, an order came from the Home Department that crime should be brought down by 50%. A few decades later, we had a chief minister who said that crime figures should be brought down by 70%. And not only that, officers who did not bring down figures substantially to meet the satisfaction level of the chief minister, they were placed under suspension. About 8 to 10 IPS officers were suspended. I mean, it's a very strange kind of situation. And then I think across the country, state chief ministers informally tell the district director generals that देखिए डीजी साहब जरा फिगर्स को ऐसा कंट्रोल में रखिएगा ताकि असेंबली में ज़्यादा परेशानी ना हो. I mean, the opposition should not be able to launch an attack on us just because crime figures have gone up. So, I mean, there is problem in registration of cases. Police show diffidence, but there's a lot of extraneous factors in this matter also. You also very rightly brought our attention to to improving the quality of investigation. I mean, one thing which must be done immediately, and this is an issue where none of the states have any serious objection to the separation of investigation wing from the law and order functions from the police. This is absolutely essential, and it is not very difficult, and the states don't have much objection. All that they need to do is to increase their manpower so that there is a dedicated staff available for investigation. It should be done. It's not a difficult proposition. With some increase in staff, this can be achieved, and I'm sure the quality of investigation would improve once we have dedicated staff, at least in the big cities, for investigation work. You also talked about fair investigation leading to fair trial. Sir, I would like to bring to your notice what a celebrated police officer said in this context. He said that the relationship between fair trial and fair investigation is the relationship between a kitchen and a dining hall. If the food being prepared in the kitchen, the kitchen was identified with the police, if the food being prepared in the kitchen by the police is dirty, unhygienic, then that shoddy investigation, that very third-class investigation, that will be produced before the judges, and then you will have problem in doing a fair trial. So, I mean, it's absolutely essential that necessary reforms are carried out. As you yourself said, the answer, I'm just quoting you, the answer is police reforms. And these police reforms have been languishing now for 14 years. Now, 14 years is a long enough time for any assurance to be fulfilled, for any promises to be made up, for any project to be achieved. 14 years is a long enough time. Why has it taken us so long? See, we have been talking of police reforms now for 40 years. I mean, starting from National Police Commission. In fact, for the first time, police reforms were talked about in 1902 by the Fraser Commission. But let us forget that. At least since independence, after the National Police Commission was instituted, they raised for the first time the question of reforming the police. And it is now 40 years. And still we are struggling with their committees and their commissions and their Supreme Court judgments, and still we are not moving forward. Why? I mean, has anybody tried to work out the cost of an inefficient and incompetent police? Because once you have an inefficient and incompetent or insensitive police, the results are there in the form of more crime, bad internal security situation, incidents of terrorism, incidents of Naxalism, incidents of insurgency, and whatnot, separatist movement and whatnot. According to one estimate, 9% of the GDP is lost every year because of the violent incidents that we face across the country because of poor law and order. That's too high a cost. I mean, if a simple cost benefit analysis were to be done, and what is the benefit? The benefit is that you are able to protect your turf, you are able to protect your stooges, and you are able to harass the opposition and those who are opposed to you. Is that benefit, does it outweigh the enormous costs that we are incurring in terms of serious internal security situation and poor law and order? I think even if a cost benefit analysis were done, I mean, simple common sense would say that no, we need a well trained, well motivated, professional police force committed to upholding the rule of law. And yet we are not moving in that direction. So you also brought to our notice reforms in the criminal justice system. Very relevant points were touched by you about the huge pendency, the large number of vacancies, and that the justice delivery system is really not delivering. If cases are, I mean, we hear about cases being decided about after 30 years, 25 years. I mean, what kind of justice is this? Justice delayed is justice denied. I mean, that we heard as a child. But this is almost, happening every second day. I mean, we read in the newspapers about a case being decided after 30 years. So, I mean, this kind of system, we need to drastically change this kind of system. The Malimat Committee gave several very important and relevant recommendations to improve the criminal justice system, but unfortunately, the international human rights lobby launched such a ferocious attack on the recommendations of the Malimat Committee that the government developed cold feet and the recommendations were not implemented. Even now, I would say that there are several recommendations of the Malimat Committee which could be resurrected and which could be implemented with very good results in the delivery of the criminal justice system. But somebody has to have the courage and somebody has to show the will to reform the criminal justice system as a whole and police in particular. Police, I have always felt, I mean, I'm not being presumptuous because I am a former police officer, but police is the central pillar of the criminal justice system. If police is not improved, I mean, the other organs of the criminal justice system, howsoever, whatever effort you might put in, but they would not be able to really improve things. Police is the central pillar, and the central pillar must be not only revived, it must be strengthened, it must be reinforced, it must be reformed, it must be restructured, it must be rejuvenated. That is why I strongly feel, and police reforms, taking a broader view, I would say that police reforms are relevant for the survival of democracy in this country. The kind of, the way criminals are entering the parliament, I mean, persons with criminal background or shady background who have cases registered against them, their numbers are steadily going up. I mean, at the last count, it is 43. I mean, it started, 10, 15 years back by about 25 or 30, and now we have gone to 43. The year we crossed 50%, I think we are done. We are done. So, I mean, and the police, why I'm referring to this, because police is supposed to protect these persons, police is supposed to salute these persons, police is supposed to carry out their directions also, and directions mean investigation, I mean, interference in investigation, and influence in investigation and whatnot. I mean, if these are the people who are allowed to have a say in the affairs of the state, then the future of democracy is not safe. And then for the economic progress of the country, can you have economic progress in a country where law and order is not good? Certainly not. Any investor first looks into, what is the security scenario? How secure would my investment would be? So good law and order is an absolute necessary precondition for sound economic development. So the stakes are very high. The stakes are the democratic structure. The stakes are the economic progress of the country. The stakes are at stake is the internal security situation of the country. police reforms are absolutely must if we are to progress and bring up India as a progressive modern state. Thank you, sir. With these words, I thank you once again for what was a very enlightening presentation, and I'm sure you have given food for thought to many of us who are not only here, but tomorrow when the contents of the speech are broadcast across the country, I'm sure many people would be set thinking about what needs to be done to prevent what you said, the collapse, whether it has already taken place. I mean, that this for the first time I heard whether the collapse has already taken place. You have raised this question. It's a very serious matter, and if the collapse has taken place, then it's a very dismal scenario. With these words, thank you once again, sir. We are very grateful that you graced our Foundation Day function.
Thank you.
Thank you, Prakash Singh ji. And thank you, Justice Lokur. Can you hear me?
Yes, yes.
You have kept to time, sir, absolutely to the dot, both of you. And I congratulations for that separately. Justice Lokur, for the insightful thoughts and for bringing the issue of police reforms along with the criminal justice system reforms. Thank you very much. I'm Vipul Mudgal, and I would be just keeping the post office today. I'm just collecting questions. As you know, that this program is being live streamed on Facebook and YouTube. In fact, on multiple channels of Facebook and YouTube, about 5 to be precise. And we are constantly receiving your comments and suggestions, even the short ones on the screen. And they are in thousands, and I would definitely will read all of them one by one and take them as like feedback, or we will definitely study them. And there are many questions which are coming directly to me, so I will put some questions to you. And one of the questions, I would say the first question is exactly on the same subject that Mr. Prakash Singh finished his thoughts on. So in fact, I should have asked you to actually speak, give your comments on what Mr. Prakash Singh said. And I would also add this question there. So if you like, you can do combine both together. This says, how do police officers maintain neutrality in the face of polarization efforts by political leadership? Who will take the lead?
Vipul, that's a very difficult question to answer. Who will bell the cat? That's really the problem. Now, I frankly don't know how the police can stand up to an overbearing or an overpowering executive. But somebody will have to do something about it. There are allegations, but not allegations, but there are commentators who have said that even the judiciary is succumbing to the pressures of the executive. May or may not be true, but how does an institution, whether it is the judicial institution or whether it is the police, how do they stand up to an authority which puts pressure on them? Mr. Prakash Singh is obviously correct in saying that there are all kinds of pressures, to bring down the number of cases that are being registered, to bring down the fact that to publicize the fact that the number of cases that the number of crimes that are occurring has come down because of better policing and so on and so forth. But unless there is this transparency, unless there is accountability that is foisted on everybody, transparency, I think, is very, very important. Unless that is made available to the people, we can never get rid of these pressures. Frankly, I find it a little surprising that the NCRB gives data of 2018 sometime towards the end of 2019. The data of 2019 is still not available, but towards the fag end of 2020. but 2019 information is not available. We have computers. These are numbers which any computer can crunch. Why should it take so long? So therefore, whatever discussions we have, relate back to information that we have, which is 1 year old or 2 years old. So unless we speed up, data collection, data gathering, make it more scientific, it's very difficult to say how to get rid of all these pressures. You can't say no to a chief minister. It's difficult for the Director General of Police, but if the Director General of Police says, "Listen, I'm going to say no to you," I don't know what will happen. But yeah, perhaps we need somebody to say that. We need a couple of people to say that.
So, Justice Lokur, you also talked about, the fair trial is a human right of every citizen. Sir, today we see very often that dissent is being criminalized. So we also see that there's enormous pressure on victims and witnesses, etc. So, there are generally kind of gloom around. There's dark clouds. Do you see some hope as a senior person who's seen it all? Sir, do you see any hope around for us?
Well, efforts are being made, for victims, for example, more particularly victims of sexual offences. Efforts are being made not only by the police but also by the judiciary to make the courtrooms more victim friendly. Right? There are judgments of the Supreme Court. They have been implemented to some extent in some courts. I know in Hyderabad, for example, they have a center managed entirely by the police or on the initiative of the police called Bharosa, which is like a one-stop center where medical advice is given, counseling is provided, legal services are provided. So these are efforts that are being made, but the problem is that they are being made in a few places here and there, and ultimately these become ad hoc sort of arrangements that won't take us anywhere. It has to be a huge concerted effort by everybody, by the police, to bring about some reforms. Why is it that from 1971, forget about 2006 judgment, assuming there was no judgment, is it that the recommendations of the National Police Commission are just to be kept on a shelf? It's been what, almost 30 plus another 20, 50 years. The reforms have not been brought in. What about the courts? The Chief Justice of India said in 1985 that the system is on the verge of collapsing. What have we done about it? So everybody has to work. And I had mentioned the Supreme Court said that nobody is objecting to police reforms. But in spite of that, they're not being implemented. Why is it not being implemented? State governments are not implementing it. Union territories, which are under the central government, they are not implementing. Why is that? We need to ask a lot of these kind of questions before we get answers to them.
Sir, there's a question about prisons.
Yeah.
It says, is it possible to have a mandatory review of the sentences of prison inmates not convicted of life sentences to ensure that they don't serve a longer period than what is due?
Oh yes, I think it's very important. It's very important. Let me tell you, I had gone to an observation home in Delhi for observation home for boys. That is minors who had committed offences. Under the law, the maximum sentence that can be awarded is 3 years. I'm talking about 2007 or 2006 when I had gone to the observation home. I found a very large number of children who had been in the observation home for 5 years when the maximum sentence is 3 years. When I requested the Juvenile Justice Board to take up the case of each child individually, Out of 258 children who were there in custody, after a month-long exercise or 1.5-month exercise, the number came down to 48. 210 children were there in custody when they should not have been in custody. That sort of an exercise must be undertaken in all prisons. Unless we do that, you will still have cases of persons who are there in custody without any rhyme or reason. There are instances where persons are in custody because the bail bond is, very high. Surety, you have to produce 2 sureties of 50,000 each. People can't produce sureties like that. But then they have to spend time in jail. The law says that even in these kind of cases, reduce it. But no, the jailer says no. The prosecution says no. Anyway, he's in jail. How does it matter to us? So yes, there has to be, prison reforms. We had tried to do that when we were in the Supreme Court, a bench and myself. We tried to do that. We had under trial review committees. But again, the initiative has to be taken by the state. And unless they do that, we'll just go on discussing these kind of things.
So there's a question comparing India to United States. It says that following the George Floyd protests in the US, there is a public movement for defunding and demilitarizing the police. In India, police brutalities are common, but public outrage is not very common. The question says that it's sporadic. How would you reconcile the differences in the two democracies about police brutalities?
Yeah, well, in India, we use the lathi very frequently. I mean, the police uses the lathi very frequently. They don't need guns, right? I think a report that has been given by Common Cause about policing in India, if I remember correctly, it was Common Cause, maybe the CSDS,
Yes, sir.
is that the police, there's a shortage of arms among the police. Now, I think if you give more arms, to the police, you will have more instances of people trying to snatch guns and getting shot. Right? Lathis which are being used will be substituted by guns, which I don't think is a good thing at all. Right? But yes, you're right. People don't protest in India. They do peacefully protest. If you remember, the protest against what happened in the rape and murder of Nirbhaya was a peaceful protest. Right? What happened in the India against corruption in the Ram Leela grounds was a peaceful protest. So people do protest in India, they protest peacefully. So if you compare peaceful protests with, the police having lathis, I think the balance is tilted in favor of the police. The second thing which I would like to mention is that of late, it has happened in UP and I believe it is going to happen in Karnataka as well. Whenever there's a protest or a demonstration and there's damage to public property, a law is being invoked to recover the money from the protesters. Right? That you're damaging public property, you better pay for it. Fair enough. But there are instances which have come on television in Delhi, in some universities, where the police have damaged CCTV cameras, where the police have damaged motorcycles of students that were just lying parked. I mean, you're walking around, what do? Pick up a lathi, break the headlight or break the tail light. Has the police been held accountable for that? Can the police, which represents the state, say, all right, we are going to damage and break CCTV cameras which cost thousands of rupees? We are not accountable. But if you do something to, somebody's property, to the state property, you are accountable. But we can get away with damage to private property. We can get away with damage to public property. That accountability must also be foisted on the police. It's only then that we can have this, some kind of an equality between the rights of the police and the rights of the citizens.
So there's a question on a very simple question, but I think it's straight, but not that easy. How can the judiciary prevent the misuse of central investigative agencies by the executive?
Well, it's a simple question, but like you said, difficult to answer. You know, uh, if you go back to 1990, middle of 1990s, when the Jain Hawala case had started, right? The allegations were against very senior political leaders. There was an apprehension in the mind of the Supreme Court that, well, because allegations were made against senior politicians, the investigations may get completely delayed. So they decided to monitor the investigation. The Supreme Court did not interfere in the investigations. They cannot interfere in the investigations, and they did not. But they monitored it only for the purpose of seeing that you're going in the right direction. Right? We had that experience in the coal scam, where again a very large number of important people were involved in the allocation of coal mines. CBI was investigating. We monitored the investigations. We did not tell the Supreme Court, did not tell CBI how to carry out the investigations. Just make sure that, listen, you're going in the right direction. So, in some of these cases where it becomes necessary, the courts can monitor investigations. Let's be very clear. The courts cannot interfere in the investigations. That is the sole prerogative of the investigating agency. But to make sure that the investigation does not go off at a tangent, the courts can monitor the investigation and bring them back on track. I think that is the solution to ensure that the investigating agencies do not write
Do not
the.
report to executive. Can they report to the courts?
They report to the executive, and if the courts feel that in a given case, in a public interest litigation, if it does come about, certainly the court can pass an order. They did that in the Jain Hawala case. It has been done in the coal scam case.
Coal scam.
Yeah, it can be.
So there's a question on what you said about the FIRs. If the state governments in the country were to issue strict directions to record every FIR in police stations, how do you see what will happen to mountains of cases pending in the courts?
Well, it's not that every case, every FIR will come to the court. When an FIR is lodged, the police will investigate, and they will file a report under Section 173 of the CRPC to say that, well, an offence is made out, so therefore we are filing a charge sheet, or they will file a closure report. Okay, so if they file a closure report, that's the end of it. There is no trial. So really, I think this is a fear which is generated. I had mentioned about the fear of misuse of the provisions of Section 498A, for example. There was a fear that was expressed that the Scheduled Caste, Scheduled Tribes Prevention of Atrocities Act will be misused. But it has not happened. So even if the state government's mandate, one doesn't know, it may not happen that there'll be mountains of FIRs or there'll be mountains of cases. It may not happen. But certainly it will bring some sanctity to the process. And if people file malicious FIRs, action can be taken against them.
So there is time perhaps for just one more question, and this is, do you think NHRC needs more powers to recommend immediate action in certain cases?
Oh, yes, definitely. Definitely. The NHRC filed an affidavit. The NHRC filed an affidavit in the Supreme Court saying that they are toothless. It's like a toothless tiger. Why? They are understaffed. They are overworked. They make recommendations. Those recommendations are not binding. Now, under these constraints, if the NHRC is to function, it's just filling in the gap sort of a thing. So really, I think more powers have to be given to the NHRC.
So I'll take the privilege of asking the last question. Sir, do you think there should be some provision for compensation for the victims of the judicial system? If you've been kept in jail for 14 years and there's no charge against you, or things like that.
You see, it's like this. If a person is kept in jail for 14 years, who is responsible? It can't be a judge, because the judge doesn't go to the jail every day to find out. Right? It's the prison officials who are supposed to know who is in jail, why is that person in jail, how long is that person supposed to be in jail. Right? So the primary responsibility is that of the prison officials. The prosecution also should be aware of the fact that we have made sure that this person goes to jail through our proper investigation and proper presentation of the case. And he should come out by a particular date. Has he come out or has he not come out? That is a check that can be placed on the prison official. So the primary duty really is that of the responsibility is that of the prison official. It is also a secondary responsibility of the prosecution. If in spite of these two people bringing it to the notice of the court, first of all, they should not bring it to the notice of the court. If the person has to be released, he should be released. But if for some reason that person is not being released, that's when the court comes in. The court is not monitoring the prisons. So I don't think the judiciary can be held accountable. It's too far removed from the actual happenings.
So, Justice Lokur, thank you very much. I think the questions are now streaming in. So, I'm really sorry we had to finish this, and I know that questions will keep on coming, but we'll definitely, Indian Police Foundation, we.log, and Common Cause will continue the dialogue on police reforms in India. Thank you very much, and over to Sudhirji.
Vipul, Sudhir is on mute.
Sir, your mic is... Yes.
Thank you very much, Vipulji. Honorable Justice Shri Madan Bhimarao Lokur, former Judge of the Supreme Court of India. Shri Prakash Singh Ji, Chairman, Indian Police Foundation. Shri M. Ramachandran, President of the Indian Police Foundation. Distinguished guests on this virtual show, ladies and gentlemen. It is my privilege to deliver the vote of thanks on this hallmark occasion. Thank you very much, Justice Lokur. We are indeed grateful for your candid and inspiring delivery that all is not well in the police and in the criminal justice system, even going to the extent of cautioning about the collapse of the criminal justice system. I hope this occasion will once again draw our intellect and determination towards this critical area of concern, which has been eluding us for the last so many years. We all believe and talk about police reforms and reforms in the criminal justice delivery, but perhaps the buck stops here. For the last 3 decades, far too many reports on police reforms and reforms in the criminal justice system, from the recommendations of the National Police Commission to a plethora of reports by various distinguished committees, and finally the historic Supreme Court judgment in 2006, remains tardily and half-heartedly implemented. Sir, I want to, and we want to assure you that we have not given up hope. The reforms are inevitable. It will come from within or without, we don't know, but will come someday. And sooner the better. Otherwise, as rightly prophesied, our cherished democracy will be at peril.
Thank you. Thank you very much.
Thank you, sir, and thank you, Justice Madan Lokur, Mr. Prakash Singh, Dr. Vipul Mughal, Sudhir Pratap Singh ji, and thank you everyone who has made this show possible. we.log and Common Cause. Thank you very much, and have a good evening.
Thank you. Thank you.